on behalf of Beyond Law CLC that in terms of the suggestions received from our different stakeholders or patrons, that we should do 75-part series in respect of the Constitution of India. And there couldn't be a better day to celebrate on a Republic Day with Justice Rohan Dalvi, a former judge of Bombay High Court, to speak on justice and peace in the Constitution. Its relevance on this journey of 75 sessions, coupled with matching on a Republic Day, we thought there couldn't be a better person who can actually throw the right light on this subject. And as usual, we are always indebted to Justice Dalvi to accept our invite and always to come out with different subjects and different perspectives. I will not take much time being a Sunday as well as a Republic Day, but we are all thankful that you have joined us. And over to you, ma'am. And happy Republic Day to everyone.
Okay. Yes, Vikas, thank you. Happy Republic Day to you and everyone. What I felt was that when Vikas was doing 75 sessions, a session on Republic Day would be very opportune. Somebody better than I could have done it, but if not, I was always available. What I find from the Constitution is a whole tapestry of justice and peace in parts 3, 4, and 4A. And that is what I would like to share with all these participants, essentially by way of an enumeration only today. It is said that if you want peace, work for justice. You don't have to work for peace. If you work for justice, you automatically get peace. This lovely quote I had seen in a compound of a small church in Halifax, in Canada. And it has lived with me ever since. And I felt that in our Constitution, justice, social, economic, and also political would give an entire perspective of how peace would be derived and how we would live with it in our independence and in the Republic of India when the Constitution was adopted. Justice Khanna has said, the Constitution is not a parchment of paper. It's a way of life and has to be lived out. Now, how did we get our Constitution and why the Constitution, just as is ours, to usher in justice and peace? First was the Magna Carta. And we felt that our Constitution is India's Magna Carta, the great chapter, the charter. Magna Carta was enacted on 15 June 1215, centuries ago at Runnymede in England. It granted equal civil liberties to all men. I emphasize the word men. So it considered all men equal before law. Okay? That was justice and peace in that day's England. About 250 years ago, in the United States, at the beginning of the modern age of equality, the Constitution of the United States again said, all men, I again say men, are created equal. So all men in America did not mean all men. It meant all white men, because black men had no liberties, no equalities at that time. And so did the women. Much later came the Universal Declaration of Human Rights. Interestingly, our Indian Hansaben Mehta worked with Eleanor Roosevelt in drafting the Universal Declaration of Human Rights. And there, Hansaben suggested all human beings are born free and equal with dignity, for dignity and rights. This was adopted by the Universal Declaration of Human Rights. And a couple of years later, when our Constitution was actually enacted from 1948 to 1950, Hansaben was one of the 15 members of the Constituent Assembly. These were the women members, one of the 15 women members. One of them was even marginalized from that community. And when they drafted the Constitution, with all its amendments, with 395 articles over 12 parts, at that time 8 schedules, about a lakh of words, and in about 321 pages, we got equality for all human beings and therefore equality between men and women. But this equality was to be with equity. It was not only equality as in the German constitution. The Weimar constitution in Germany essentially said equality of rights to men and women under Articles 3.2 and 3.3 of that constitution. In India, we were all human beings and certain human beings were treated unequally. Our history of centuries showed that fact. And therefore, to suit our conditions and the ground realities of India, we had special provisions for women and children to grant them equality. Now, this equality is actually equity. Equality means everyone is equal. Whether you are tall or short, whether you are fat or thin, whether you are this or that, some community, you're all equal. But this requires them to be on a level playing field. When that is not so, there should be power balancing. And that is what has happened in our constitution, which we will go through when we go through each of the articles and enumerate them. So the Indian constitution was adopted with a fair measure of agreement for all Indians, as it was said at that time. And just like the earliest legislations, the IPC, the Indian Contract Act, the Indian Succession Act, which ran like poetry, this, friends, you will find, does run like poetry when you just enumerate each of these articles in these 3 parts of the Constitution. Now, for this to be enacted, as they say, as the Upanishads had said, to set right a misshapen circumference, it is essential to set right the center point. And that center point in our Constitution is justice. The preamble shows justice, liberty, equality, and fraternity. Justice is social, economic, and political. So therefore, law plus X is justice. This is justice according to law, but the law has to be interpreted. And when the Constitution is used and abused by the governments, it has to be interpreted by the courts. And that is what we have got as a sum total and a bundle in our Constitution. The liberty that we have in the preamble is the liberty of thought, expression, faith, belief, and worship. So that also transcends all social criteria and actually is social justice. Now, as they say, liberty does not descend upon a people. A people must rise to liberty. It is a blessing which has to be earned before it is enjoyed. And this quote, friends, is engraved in stone in our Rashtrapati Bhavan. If you go for a morning walk, you will find this on the left side of Rashtrapati Bhavan. As they say, liberty is not the power of doing what is right, but the right of doing what we ought. So this liberty is for the citizens, and this liberty has an equal responsibility upon the shoulders of the government. Equality in the preamble is the equality of status and opportunity, which is economic justice. Fraternity in the preamble is for dignity of individual, which is social, and integrity of the nation, which is political. So friends, such is the fruit of our freedom. And as they say, those who deny the freedom of others deserve it not for themselves. It was said by Abraham Lincoln. Now, given this preamble and given this background, we have to enumerate the fundamental rights, the directive principles of state policy, and the fundamental duties of citizens as also the government. 13A, Article 13 is that no law can take away or abridge any fundamental right. The legislative acts as well as the subordinate legislation are covered in Article 13. The fundamental rights cannot be bartered away. It cannot be compromised by any means. Article 14 gives the equality before law and equal protection of the law. And that is not only to men, but to human beings. That is the basic feature of our constitution. No arbitrary action, the principle of reasonableness and rationality. Article 15 gives the prohibitions against discrimination. So just when you have the positive right of being equal, you have the negative right of having a prohibition against discrimination. Now, this discrimination is on grounds only, I emphasize again only, of religion, race, caste, sex, and place of birth. So if only on that ground you say that a particular person or a community or whatever is not allowed a particular freedom, it would be covered under the mischief of Article 15.1. 15.2 gives the grounds, the special provisions, gives the grounds on which this discrimination is based. And 15.3 makes special provision for women and children. Now we must understand that years and centuries before the Constitution, there were no equal rights between men and women. There was child marriage in infancy, no widow remarriage, no abortion rights, no social rights for women. When Macaulay drafted the Indian Penal Code, he thought that this was not the culture he would want, and he gave special rights to women in the IPC itself. That is the precursor of the Constitution. Their gender was not a word in fashion as we have today. It was not even minorities. It was certain rights which would be actually available only to women. But when we have the Constitution, we made special provisions for women. And in these special provisions came initially, right after the Constitution, the Hindu Code, by which majority of the Indians were governed, the marriage, succession, adoption, guardianship. All of these things came to be covered in the Hindu Code, by which the uncodified Hindu law came to be codified in 1956, giving equal rights of divorce, etc. And then thereafter, there have been various amendments to the Hindu Succession Act, Hindu Marriage Act, Hindu Adoptions and Maintenance Act, which by amendments granted special rights to women and children. These rights then came to be embodied also in legislations like the Domestic Violence Act, POCSO Act, PCPNDT Act, as we call it, the Prenatal Pre-Diagnostic Techniques Act. These all granted protection to women. Now, when we have these protections, we should not abuse these protections. These protections may have come to be abused by some of them. But it is said that not until half the population, representing women and girls, can live free from fear, violence, and everyday insecurity, can we truly say that we have a fair and equitable world. This, friends, granted, as we say, a level playing field, an equal opportunity, and to women and children, and accordingly equality to them. Then in Article 15.4, special provisions were made for socially and educationally backward citizens. This was what Dr. Ambedkar had really strived for. He did not want it on economic grounds. He wanted it on grounds of social backwardness and educational backwardness. That was the call of India at that time, because the marginalized societies that we now call social, SC, ST, etc., they did not have any educational opportunities. They did not have employment opportunities and were socially backward. So no matter what they were earning, they were still socially backward. This has come to be amended by a very late amendment in the Constitution. And that is also as per the ground realities of India at that time. And at that time, the economically backward section only required this kind of protection. So what we call the creamy layer and what we call the marginalized sections, that is the SC, ST also, earning and economically well off, would not be entitled. And therefore, there was a cut-off family income under which the various schemes of government in admissions to educational institutions and in admissions to government posts would come to be allotted, which we will show you afterwards. Article 16, equality of opportunity in public employment. So none has to be discriminated. This was economic justice. 16.3 made reservations. Now, just as Martin Luther King Jr. had said that all the citizens must be judged not on the color of their skin, but on the contents of their character, we had reservations. Reservations were meant to be for first 10 years. Reservations would uplift those who are downtrodden. Now, even in America, there is what is called the government leg up. In certain educational institutions like the University of Texas, etc., they actually give admissions to blacks because they think that this education would go a long way in removing disparities. Today, it is known as diversity, equity, and inclusion. In business, they call it diversity and inclusion. Diversity is diverse people coming into a corporation or an institution. Inclusion is in an organization when you include people from minorities and people from backward communities, etc., etc. But equity is what is the touchstone of the Constitution, because only this equity, by granting this additional rights to give them a leg up, would result in actual equality, and that would usher in justice. Now, that said, friends, there are 2 abolitions and 2 prohibitions in our Constitution after these articles. Article 17 is an interesting abolition only in the Constitution of India, and that is on untouchability. Untouchability is abolished. Untouchability is what Mahatma Gandhi had said is a blot on Hinduism. And Mahatma Gandhi said that these untouchables were the Harijans, the children of God. The other abolition is the abolition of titles which were being granted by the British government earlier and which the Indian government is not granting, would not grant. The second was the freedom of, and then comes the various freedoms. The first freedom is the freedom of speech and expression. They say without this, all other fundamental rights fade away. The 4 Ds of a healthy democracy are debate, dissent, dialogue, and difference. As Leo Tolstoy had said, I don't agree with you, but I will defend to my death your right of saying so. So therefore, they say, freedom of expression must be all-pervasive. But that was not meant to be. It was granted in Article 19A. But very soon, in the first constitutional amendment itself in the next year, a part of the freedom of expression was taken away by having reasonable restrictions. And these reasonable restrictions have been used as well as abused by the governments and interpreted by the courts to save those freedoms. It began with the Ramesh Thapar case and the Brij Bhushan case and has gone on until now. We realize the importance of our voices only when they are silenced, said Malala Yousafzai. So, friends, the freedom of expression went into also in 19B, the freedom of assembly. People could assemble and decide, discuss, and dissent. But in certain reasonable circumstances, this right of assembly of more than 5 persons is also restricted, and that makes it a social justice concept. The third in Article 19C is to form unions. This is under the labor laws, where there was worker participation and management, which was contemplated, which was a part of our directive principles of state policy. But to form unions was a fundamental right, without, of course, damaging property and persons, and that was for social justice. In Article 19D, which is today quite eroded at times, was the freedom of movement. Every citizen could move anywhere in India. So the government of Haryana cannot say that a Maharashtrian cannot come, and the government of Maharashtra could not actually say that a Bihari could not come. That was our fundamental right. Close on its heels, Article 19E was the right to reside and settle in any part of the country. This both would be social justice. Article 19F is deleted, but G is to practice profession, occupation, vocation, trade, and business, which is the economic justice. Even this has reasonable restrictions, and so long as they are reasonable, they are allowed, and otherwise, they are not allowed by interpretation by the courts. Now, these reasonable restrictions under Article 19.2 were for what? They were supposed to be for security of India, public order, friendly relations with friendly states, decency, morality, contempt of court, defamation, and incitement to offense. But they have been used, as we have seen in many cases, to shun and shut out people. This is only where the courts come into being and they are protected. The original freedom of expression was thus lost in the First Amendment to the Constitution. Now, what is democracy? The democracy is the only system that persists in asking powers to be whether they are powers that ought to be. And therefore, as one senator in America has said, we must welcome these, learn to welcome and not fear the voices of dissent. Now we go to Article 20, the protection in respect of conviction, very much used by persons who are on the wrong side of the law and by victims who are offended. The protection is for conviction only for violation of the law and punishment as per law. These laws are the criminal laws, the IPC and the Criminal Procedure Code. Then there was to be no prosecution again for the same offense, and not in compelling anyone to be a witness against himself, essentially as per the Fifth Amendment to the American Constitution, the right of silence of an accused. Article 21 gave protection of life and liberty. And the interpretation of life has been the most expansive interpretation by the courts. We wish every other law is also interpreted so expansively. It gave the right of livelihood, not only the right of survival. So as they say, you don't survive, you live. And that right is contained in many aspects. The right of speedy trial, right against sexual harassment, right against scientific techniques in criminal law, like narcoanalysis and polygraph tests, abortion rights, etc. Today it has gone until the right to die with dignity by, as we say, a living will. Now, Article 21A, which is inserted between 20 and 22, will take a little later, because 22 is for protection against arrest and detention. So, which comes in the criminal law, in the criminal justice system, the person has to be given the grounds of this arrest. He has to be produced before a magistrate within 24 hours, and preventive detention only for 3 months and not without representation. It was a notorious amendment, 42nd Amendment, which was thereafter corrected in the 44th Amendment. Article 21A, which came to be inserted as a fundamental right much later by a constitutional amendment, was initially a directive principle of state policy, the right to education. From directive principles to fundamental rights, free and compulsory education between 6 to 14 years. Now, today in the directive principles of state policy, we have state striving to be giving education to children of tender years below 6 years of age. And that is how we have got Anganwadis and Anganwadi workers. This right of education, they say, education is a better safeguard of liberty than even a standing army. That done, we go to the prohibitions in the Constitution. These prohibitions are not much talked about. This is because these prohibitions are against really and truly the downtrodden people. Downtrodden people who are victims of offenses. Under Article 23, trafficking in humans and forced labor is prohibited. Yet there is trafficking for sexual purposes, trafficking for employment, trafficking in various ways. And that is now covered under the ITPA, the Immoral Traffic Prevention Act, the Bonded Labor Act, the Protection of Children Act, etc. So we have various laws made under this article. 25, Article 25 is the freedom of conscience and religion, and followed by 26 to 29, which deals with various religions and faiths of the peoples of India. And that is the right to manage religious institutions, no payment of taxes for practicing any religion, no religious institutions in state educations, and state aid to all. Minorities are also covered, and they can have their educational institutions. And 29 deals with conservation of culture. Culture is of all the very diverse peoples of India. Article 30 deals with rights of minorities and the state aid which is given to all. 31 relates to, and all this is social justice. And 31 then gives economic justice. There used to be the right of property, which was the fundamental right under Article 31. That is no longer a fundamental right, but it is replaced by compensation for acquisition of land or any property. So that is the economic justice of today. And Article 32 is the all-encompassing social justice, because that is the right to constitutional remedies, an aspect perhaps only in our constitution. The interesting aspects to show you that that is so widespread are actually the directive principles of state policy. Article 37 says that though not justiciable, they are fundamental in governance, and hence the duty of the state to apply these principles in making the law. And we may see how the government today applies those principles. Article 38(1) is the social order for promotion of welfare, again of peoples, for in which justice, social, economic, and political, which is meant and shown in our constitution also, shall inform all institutions of national life. Article 38(2) is that the state to minimize inequalities in income, status, facilities, and opportunities. This may perhaps be done on an individual level in many fields by certain schemes of the government. But 39B, which was very much used in the recent times in our courts, gives the principles of the policy of the state. Now, what is the policy of the state? men and women to have adequate livelihood. That is the right to life and livelihood, and that is social justice. B of 39 is distribution of resources for common good. So therefore, ownership and control of material resources is to be used by the government in the way best suited for all the people of India. This is economic justice. Then Article 39C, which has yet not been justiciable and actually enforced, is the economic system not to result in concentration of wealth to common detriment. And friends, today you might see how there has been concentration of wealth in a few hands. This is otherwise meant to be the economic justice for all. 39D is equal pay for equal work, a very, very salutary provision. It may grant equal pay for all the persons in government employment, but in the labor field, etc., in unorganized sector, we still know that there is not equal pay for equal work. But that is social justice which was contemplated. Then in the Article 39E is the health and strength of men and women and children not to be abused. Article F, 39F, is the children given opportunities and facilities to develop in a healthy manner with freedom and dignity. These children would be the youth of tomorrow. The childhood and youth is therefore protected against exploitation and moral and material abandonment. 39A, 39 capital A, is equal justice for all in the legal system and legal aid. Legal aid and the state legal aid institutions are therefore created so that everyone can get access to justice. Then Article 40 is the organization of village panchayats. This was a dream of Mahatma Gandhi. It was not made a fundamental right or anything like that in our constitution, but and under certain amendments and amendments even to the schedules, it includes the 11th schedule now, village panchayats have been made, and in village panchayats, there is equality and representation of marginalized sections as well as women. Then comes the right to work, education, and public assistance in employment, in old age, sickness, and disablement. Under this again, there are several schemes of the government. Article 42 are the provisions of just conditions of work and maternity relief. Today, we also have a kind of paternity relief. Luckily, today, the men in the families are doing a lot of good things which was not done by an earlier generation. But maternity relief was a directive principle of state policy, and there have been various subordinate legislations there. Living wage for all workers is under Article 43 for a decent standard of life, and even promotion of cottage industries. Then Article 43A, which was by way of an amendment again, was worker participation in management. That was even in the corporate sector, not only in the government institutions. 43B is the promotion of cooperative societies, again a very indigenous provision and an amendment to the with a schedule, the 12th schedule to the Constitution. Article 44 is the beleaguered Uniform Civil Code. Now, whether we have Uniform Civil Code or not, if we have equal justice for all, and if it comes from within the community, there would be harmony in having that kind of uniformity. Until then, we may perhaps not have that. Article 45 is the early childhood and education of children below 6 years of age. Now, this is below 6 years of age because from 6 to 14 years is the fundamental right to education. Article 46 is the promotion of ST, SC, ST and the weaker sections of our community against social injustice and exploitation under which there is, say, the SC/ST Act and other provisions by way of subordinate legislations in government institutions. Article 47 is the improvement of public health in nutrition. This is another form of social justice. Article 48 is the organization of agriculture and animal husbandry. 48A, prevention and improvement of environment and safeguarding our trees and forests. It's very essential to know that this is a directive principle of state policy, and yet there are government directives for construction which is wholly unsustainable, where our forests and trees have been destroyed. And when we talk about only construction, it is not sustainable development. That would be really social justice. Then we have Article 50, the separation of executive from the judiciary, which has been going on. Now, this tapestry of law really makes a poetry. As we see each of these articles, we may feel that, oh yeah, that is really all. And yet we have another article. Just as we would see in the IPC so many aspects of crimes, when we find that everything is perfect and yet there is another section. So friends, so much for justice. But the word peace in the Constitution is not in the preamble and is in certain articles 50, 51, etc. Article 51 is for promotion of international peace and security and international relations and settlement of international disputes by arbitration. But that is not the only peace, and what is actually peace is what will come to a little later. In the chapter on fundamental duties, part 4A is Article 15AE, the promotion of harmony and brotherhood amongst all the peoples of India, transcending religious, linguistic, regional, and sectional diversities. We have to ask ourselves whether we have performed this fundamental duty and whether our government has also performed that duty. These are the factors, friends, that predict, build, and sustain peace. And when these are lost, peace is at stake because justice is not given. Now, when we are enumerating all of these articles in our Constitution, we find that there are certain articles which are completely indigenous and true only in the Indian Constitution. Untouchability under Article 17, the directive principles of state policy we don't find in other constitutions, Part 4, fundamental duties, Part 4A, panchayats, because we have the Panchayati Raj up to a point, and cooperative societies, and later even the GST, which is by way of a constitutional amendment, and a very distinct aspect only in our Constitution. Now, aside from this initial Constitution, there are certain amendments which give, abridge, take away, or grant more of the fundamental rights. We can just enumerate a few. The First Amendment, which took away part of the freedom of expression by way of reasonable restrictions, or what was called reasonable restrictions. If they are reasonable, it is certainly fine. Like, for example, not to hurt anyone's feelings is a very reasonable restriction. But how the government has used it and is using it has to be seen and interpreted by the courts. The 42nd Amendment, which then gave way to the 44th Amendment, and let us not go into the dark days of emergency. At the 65th First Amendment was the age of voting, which came to be reduced from 21 to 18 years, and which gave at that time about 5 crores of citizens who could vote. The youth of our country, which the then government said was the dream of India. The 73rd Amendment and the 74th Amendment created the panchayats and the Panchayati Raj and the municipalities. The 86th Amendment was the right to education, which made it a fundamental right under Article 21A. 99th Amendment was the ill-fated NJAC, 101st Amendment was the GST. And 103rd Amendment was the reservation on economic criteria, which excluded the creamy layer, which was at that time opposed by Dr. Ambedkar. But that was in the ground realities of India at that time. And then the ground realities changed for the better economically. And this was then the economic justice. This was the entire concept of affirmative action or positive discrimination in our constitution for women and children and for backward communities. Then, friends, as they say, when injustice becomes law, resistance becomes duty. That is what Thomas Jefferson had said. The reservation of blacks in India, the reservation of Dalits in blacks in America and Dalits in India fall under this category. And all together, to grant them this justice is the concept of peace. Now, what is peace? Peace is not absence of war. Even when you have no war, you may have not peace. There may be lack of peace in families, in communities, in social organizations, etc. So the concept of peace transcends all that and should be lack of conflict. Armed conflict of war between nations and communities and terrorism is one aspect. Structural conflict is also lack of peace. And 100+ countries are supposed to be having structural conflict, including our country, as per the United Nations report. Now, therefore, friends, we see, just as we saw the positive discrimination or affirmative action, we have to see what is negative peace and positive peace. Negative peace is no war, but no peace either. Positive peace is no structural and cultural violence. So it goes beyond equity, freedom, and harmony. Now, what are the causes of these conflicts? These are corrupting democratic structures, which we have a lot today. The climate change, no water, which has been the cause of conflict in many a country. Natural resources, for example, gas, for example, in Nigeria, which has been the cause of conflict. The need to feed economies, the economies to get the GDP have caused conflicts. The rise of nationalism, for example, in USA, India, Myanmar, Iran, all of them have led to conflicts. The economies of peace, therefore, are greater security, better business, and consequently, higher GDP. So what our constitution teaches is the spirit of education, the culture of understanding, the attitude of tolerance, the level of progress, and consequently, the atmosphere of peace and prosperity. And as they say, peace is possible. That is bridging the gap between theory and practice. So friends, as we have seen the poetry that is in our constitution, we have to find what is the practice of all that we have got from our constitutional freedom fighters and constitutional framers on this day today, 75 years ago, so that we can see our future to the 100 next time. Thank you, friends.